Morning.
Good morning.
Mr. Amin, you need to turn on your video.
All right. Hello. Hey. How you doing?
Oh yeah, this is all Alyssa's fault. It's good stuff.
Well, are you out of bed this time?
No, I'm in my room right now. Like,
This is 24RO05235. The citation was issued on the 29th day of June.
yep.
About midnight, you were cited in the area of 11 Mile Road and Woodward Avenue for speeding 60 and a 35. You have three options this morning. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
All right. So I was like,
I asked you, how do you wish to proceed? Are you admitting or denying responsibility?
I admit, but I was really tired that day. I was doing like overtime, and I got off work. I just wanted to go home, and I didn't realize that I was like going above the speed limit, and I get pulled over. You know, like it's like I feel like
Mr. Mann, everybody on the street
yeah.
in their car because they want to be someplace else.
Yeah, I apologize.
be
I know
home.
it's my fault. I know it's my fault. Like, is there any way like you like forgive me? Like, please, like.
Also, the fine is $200.
Yeah, I know. Is there any way like you forgive me? Or, like,
No, it's not the function of a court to forgive.
like you give me a
You
chance.
did something that was illegal. The consequences for your conduct are a fine. The fine is $200. It needs to be paid. You can pay it online. You can mail in a check or money order.
Can I get more time to pay for the?
It's not the function of a court to forgive. It really isn't. I'm not your girlfriend that you cheated on or something. You know, you got a case. You're guilty. Here's the fine.
Well, you've spread this out over quite an extended period of time. You got this ticket back in June, and here we're written here in December, so you've gone about half a year already. How much more time do you think you need?
Can I get like a month, like one more month? Because I'm paying for like my bills and stuff.
I can give you 2 weeks.
2 weeks. Okay, that works.
Judge, I'm paying for my bills and stuff.
So when is the 2 weeks? What day?
Today is the 25th day of November.
20.
2 weeks from today is the 9th of December.
9th of December. Okay. All right. Thank you.
Thank you. Have a good one.
You too.
Thank you, sir. May I have another?
This is citation 24RO07376. Mr. Akins, the ticket was issued on the 12th of September, about 9:20 in the evening. You received two tickets. One was the speeding ticket, 55 and a 35, and the other was the citation for driving without a cycle endorsement. As to the speeding, how do you wish to proceed?
Not guilty.
As to the driving without the cycle endorsement,
I have a permit, so I'm
I asked
guilty
you,
of that.
where are you, on the date you got the ticket, did you have an endorsement to drive a motorcycle?
No, sir. I have a permit. I don't have the endorsement.
Do you have a permit for driving a motorcycle?
Yes. But in the permit, I need a licensed cycle endorsement operator riding with me, and there was no one with me. It was someone following me.
This defendant is actually kind of likable. He's a veteran. He's sincere, but he's wrong, and he gets out of control.
Who was following you?
A friend of mine. We were going to downtown Royal Oak. He was in his truck. He was right behind the officer.
Okay, but he wasn't on a cycle.
Sir, no, sir.
Each raise your right hand, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
Yes.
Okay, the officer will testify first as to the speeding rate.
So originally I was at Campbell and Gardenia running radar, and I got the reading that he was doing 56 and a 35. And just to clarify, I'm certified in using the radar. It's tested before and after my shift, so I know it was operable, and there was it passed the physical tests. It took me a little over a mile to catch up to him. When I first originally saw him, there was no other car with him. He was by himself, listening to his music very loudly, going south on Campbell. And then that's when I conducted the traffic stop at 11 Mile and Campbell at the mobile gas station. And that's also when I asked him if he had a cycle endorsement. He told me that he had a permit.
What does the permit, what are the requirements of the permit?
You need to ride.
Oh,
You need
I'm
to
sorry.
ride a person that has a motorcycle endorsement already. That's 21.
Does that person need to be on a motorcycle?
I believe they're supposed to be riding with that person.
Okay. And that was your understanding too, Mr. Akins, wasn't
Sir, yes, sir.
it? Okay, as to the speeding, please, Mr. Akins.
Well, I know I wasn't speeding. First and foremost, I have someone following me that does not know where they're going. Secondly, I live on Campbell, and I'm always complaining about speeders. So I'm very mindful of my speed on Campbell.
You're mindful of your speed.
Yes.
You complain
Sir.
about speeders on Campbell.
Yes, sir. I've been hit 3 times on a motorcycle.
I can feel the judge's sarcasm. Oh, you're mindful of your speed. Mm-hmm.
So I'm very mindful of what I'm doing and where I'm going. And as for the loud music, yes, I do play my music loud because I've been hit 3 times. They said they couldn't hear me nor see me.
How fast were you going?
I was doing 35.
How do you know?
I have someone behind me that's following me that does not know where to go, and that is the speed limit on Campbell. I live at the corner of 13 and Campbell.
As I understand your testimony, you know you were going 35 because there was somebody driving behind you.
Well, I'm mindful of my speed because nobody wants to hit a kid or anything on Campbell. Kids play on Campbell. It's an intersection where a lot of people want to fly up and down the street, and there are kids crossing the street. Not only kids, but pedestrians crossing the street.
There's a school right at 12 in Campbell.
Yes, there is, right next to the Speedway, across from the Royal Oak yard.
Mr. Stokes, when you measured Mr. Aiken's speed, were you in mobile mode or stationary mode?
I was stationary. He was coming from 13 miles south on Campbell towards me.
And you were in a fully marked police car.
Yeah, I believe so.
Mr. Aikens, the officer is certified to operate radar. He was operating it. He put the unit through a series of tests before he started the shift. It's testified that when he put it through the series of tests after the shift, it was working still. The radar
Might
unit,
I ask a question?
when I'm done talking,
Yes, sir.
the radar unit cannot fix itself. If it breaks, it needs to be fixed. If it's operating at the beginning of the shift and it's operating right at the end of the shift, it's operating right during the duration of the shift. What is it that you wanted to answer?
Well, there were like 5 or 6 vehicles around me. So how am I speeding and I'm behind vehicles? That means they have to be speeding as well, correct?
Not
Or no?
necessarily.
Okay.
Not if you're
Yes, sir.
passing them.
I'm not passing them, no.
You've admitted responsibility as to the violation of the permit.
Yes, sir. Sir, yes, sir.
Fine on that is $200.
They were also kung fu
You
fighting.
testified that you weren't speeding, that you're concerned about people speeding in that area, that you live there. You've complained about speeders. And I don't doubt that at all. The bottom line is your rationale for knowing how fast you were going was you had another person following you. The
But I'm
officer
also paying attention to
operating,
my speed.
twice you've interrupted me.
I apologize, Your Honor. I
The
apologize.
officer was in stationary mode in a fully marked police car, and you drove past a police car without seeing that he was there. Maybe that had something to do with your speed. Fine on this matter, I do believe you're responsible for the reasons I just stated. And the fine is $200. Secretary of State does not give 2 sets of points to the same person in the same day. So there's only 1 set of points here. And those points come from the Secretary of State, not the court. I'm not aware of your driving record, so you may or may not get the letter from the Secretary of State that will tell you how you can stop the points. We're going on to your record. These fines need to be paid. They can be paid online, by mail, or at the courthouse counter. Whatever is more convenient for you, sir. Thank you.
Might I ask a question now, Your Honor?
Go ahead.
Okay, so have you ever ruled in favor of somebody that wasn't speeding? Because I was not speeding. It's over with now. I know I have to pay the fine. But at the same time, I was not speeding. I was not.
Mr. Rick, I don't think you'd be here if you thought you were.
Well, at the end of the day, if I do something wrong, I fought for my country. I've been shot at for my country. I can be honest for myself.
I don't
But
doubt that for a second.
at the same time, if I feel like I'm being unjustly accused of something, I'm gonna stand up for myself.
I hope so.
And I know this is wrong.
Well,
And at the same time, when is the last time you ruled in favor of a person instead of an officer? Because officers lie. Police officers do lie.
and people who get tickets never do.
No, if you look at my record, if I got a ticket that I deserved, I took it. Like the driving
You're not the
without
judge, sir. You are not the trier of fact.
You're right. You're
Mr. Estan, this ticket is 24 RO 06815. Was issued on the 20th of August, about 1:09 in the morning, in the area of Royal Oak near Main Street in Hudson.
Yeah, I missed the last little bit, Alyssa. I was trying to put it all together. He does come back for a second, and it's honestly the best part, but I missed it.
You were cited for speeding. The ticket was issued at 45 and a 30. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I can admit with an explanation.
What is that, please?
I wasn't going 45. I was going about 5 over. I was delivering Uber
Okay, so you're admitting
when it
responsibility.
occurred.
You're admitting responsibility for going 45, and your explanation is you weren't doing it. That it didn't happen.
I'm sorry. Sorry, my connection was
If you raise your
acting
right
up. I'm
hand,
sorry.
please raise your right hands. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
Mr. Estes? Okay. The officer will testify first.
I'll start off with I'm certified in using the radar. The radar is tested the beginning shift and the end of shift, and it tested fine that day. There was no errors. I was sitting on Main facing northbound. I had my rear stationary, same direction, radar activated, and I got a reading of Mr. Esteim's vehicle traveling at 45 miles an hour in a 30-mile-an-hour zone.
Thank you. Mr. Estes, it's your turn, sir.
I was delivering Uber. I was going about 35 miles per hour, going 5 over. I seen the officer already sitting there from before and even slowed down my car 5 miles over under that speed limit. And then he pulled me over and told me I was going 45. I didn't argue with him in the moment as well because that's not what I do. And
What, sir? The officer was stationary, parked on the street. You drove by him. He measured your speed as you were approaching him, and you slowed down when you saw him. That appears clear. It also appears clear that the officer checked the radar before and after his shift. It worked at the beginning. It was still working at the end. There's no reason to believe it wasn't working in the middle. The other factor here is that he measured your speed at 45 in a 30. You've admitted that you were speeding. The only issue is how fast you were going. And that issue appears clear given the fact that the officer measured your speed with radar.
but there were also other cars in front of me as well. So I would just say he wasn't checking their speed because I know I wasn't speeding. But again, I'm not going to argue with the officer when he's giving me a ticket. There's been many incidents going on where people argue with the officers. I'm not going to sit there and argue.
Well, I'm
with the
looking at the
officer
number
about
of tickets
how
that
driving.
you've received. So you obviously are not.
Yeah, I've gotten numerous tickets over stupidity of speeding tickets. I've just had a ticket in Hazel Park for going only 6 miles over the speed limit, which was ridiculous. And I even had a witness in the car. The
Your actual
only
speed
reason
was
why I
listed
couldn't
at
fight that
32 and your
ticket was
posted
because
speed
I
was
never
25. So you were cited for driving 7 over the speed limit. Why is that ridiculous?
Yeah, and I wasn't, but it was because I wasn't speeding. I even had a witness in the car, and the only reason why I didn't get to fight that ticket was because I never even got the thing in the mail, even after I called over to get the court date. So they ended up giving me a ticket for that. I'm not even currently living in Michigan anymore. I've been living in Miami, Florida now. And I've been driving the exact same way I've been driving in Michigan and haven't gotten a speeding ticket at all since I've been out here. Like, I don't have no reason to lie. I'm a truck driver. Like, I'm not going to sit here and just speed the speed, especially if I've already had seen the...
I don't have any reason to lie. I'm a truck driver. Well, that's a fantastic reason to lie and try to avoid a speeding ticket. That follows on his fantastic argument that, Judge, I know I wasn't speeding because I get stupid tickets all the time, for speeding.
Officer stationary sitting there. Doesn't anybody, when they see a police officer sitting there stationary, what do? They slow down. I wasn't speeding, but if he says
You're going 45 miles an hour, sir. The speed limit is 30. You were speeding. The fine is $170. It can be paid online, it can be paid by mail, or you could drop by the courthouse and pay it if you're back in Michigan. In any event, we're all set. Have a good day, sir. We have to check. We've got Carmel.
And another one bites the dust. Okay.
All right. I have two
not
cases
seen
left
it.
on the docket, and I anticipate that at least one of them will be having a trial. I would like to check, frankly, the status of the latter case, and I'll call that case now. We're on the record in Hector Van McGregor versus Julie Hope. Case number is Butler County 24 LM 1193. Mr. McGregor appears in person and by and through his counsel, Kurt Holmes. I believe Ms. Hope appears as grateful legal advocate. This matter is before the court, with the court having stayed the earlier writ in the case and having set the matter for a hearing here and now, as was requested by Ms. Hope. Depending on the nature of how the parties are wishing to go forward, I might take up the other trial first, or try to ascertain what people are indeed wishing to do. Ms. Hope raises several issues, but the one that I was the most keen to try to understand today at this point is there was a document submitted alleging that the plaintiff in the case might have a different perspective or a different way forward. And I guess I might defer to you, Mr. Holmes, to advise the court as to any opinion you may have about that document, or what you would like to do at this point.
Your Honor, I would have to defer to Mr. McGregor as to what he wants to do today. I'd have to ask him in front of the court.
All right. Mr. McGregor, I do have the document that was alleged to have been written and signed by you on the 18th of this month. What indeed are you wishing to do at this time, sir?
I wanted the eviction to happen. And this document that I signed was post eviction to help Miss Hope get the eviction notices off her record. And she submitted that in that process. That is my wish, is to have the eviction served.
Okay. Ms. Hope, with respect to the question of the eviction proper, was there anything you wanted to say about this document that has been submitted?
Good afternoon, Judge Murfin. Thank you for your time, sir, and thank you for Butler County District Court's time. And thank you to the state of Kansas. I am very appreciative for this opportunity. My first question, sir, are we on record on for this case?
Yes.
So this is all available this is all being transcribed, sir?
It's being recorded by the Zoom hearing that we're all on. So it would be possible to access the audio and visual from the Zoom hearing.
So it will be submitted in conjunction with today's hearing. Is that correct, sir?
Well, I'm not sure what you mean by submitted, but it's being recorded and it would be available. Yes, ma'am.
It will be transcribed
It'll be on Law Talk with Mike, you old biddy. Let's move on.
with the hearing
It will
case.
probably not be transcribed absent some sort of an order concerning transcription, but it is being recorded.
Well, I want to be sure that I stayed on the record twice. Then the defendant, Ms. Hope, and I speak in the term the defendant as this allows me to better communicate to you more effectively, sir. The defendant is still under the doctor's orders that her mental capacity is still not rendered fully capable. And I've submitted that documentation, and I've noticed that there hasn't been any.
Oh, sweet Jesus. I just noticed now her box says grateful legal advocate. which means she's not an attorney. I don't know why that she's being allowed to speak, but okay.
I honestly don't know what that means or if it has any bearing in this case. And I don't really understand what's going on this today, but I am grateful for this opportunity to participate. And I will do the best that I can since I don't have.
Okay, I don't understand why she's talking at all. If she's a guardian, or she's been adjudicated involved in this case somehow, or she's an attorney, then she can be talking. I don't know what this woman is doing here.
Counsel at this moment, which I'm working on the process of securing. But in terms of your question, sir, will you please repeat it respectfully?
I just wondered, with respect to the document you had submitted from Mr. McGregor, what opinion you had with respect to that document.
Well, can you be more specific in what you're asking me in that question? Because that's a very broad question, sir.
Well, what do you think it stands for, and what do you think the court should do with the document itself?
Well, Your Honor, the defendant submitted this document as evidence because Mr. McGregor stated that this document could be used to appeal and I apologize, I'm having anxiety, to appeal and any of these writ of restitutions in whatever that document says. So my understanding was that that was the case. And also in a follow-up conversation, Mr. McGregor stated, the defendant asked the plaintiff, why did you sign this?
Anxiety leads to constipation.
This written statement, and he stated that it was because he thought that it would not be filed in time for the court to hear it.
Okay.
And so my understanding with that, it was in his belief that
I don't know. I haven't seen this. I don't know why this woman is talking. She's not party to the case, and she has nothing to add. She's not a witness. I don't get it.
his conduct, like
We will find
many
out.
other points in the briefing submitted by the defendant today, to include the previous motion submitted on the 18th, was just another instance of the plaintiff believing that his actions were above the law in this case for some reason. So
Okay.
he and I both,
Okay, so it's her, but she's referring to herself in the third person and doing this whole I represent. Okay. It's the soft sit crap. All right. We finally have an
was
explanation.
the person who even stated that he wanted to dismiss these cases. My understanding, and the defendant has some safety concerns in speaking out about these matters because of the many injuries that have occurred as a result of these claims, in an attempt to cause defamation of character to the defendant's personal, professional, and legal records for the case, and just for her livelihood, her financial livelihood, and merely an attempt to allow access to the plaintiff to have easy access to exploit the defendant sexually whenever he sees fit. This can also be proved in a voice memo that was reported this weekend, where the plaintiff states explicitly that he in fact likes the idea of having the defendant here for him to be able to come to and receive sexual benefits from these ongoing matters.
Okay.
Hey now.
Mr.
And Ms. Hope requests also that this case be continued
You know what this
when she
sounds like, don't you? I'm feeling it. Are you?
Exciting and new.
has the an attorney present to represent her in this case, as this is a very complex and it involves appeals of 3 evictions, and it's merely an attempt for the plaintiff to elude and not be responsible for financial litigation, as these 2 individuals have had an ongoing relationship, sexual
Sandy, I think we'd all be overcome with desire, and she knows that. So she's sparing everybody.
relationship, sometimes consensual, other times not consensual, other times exploitative, over the past years, where
I mean, you never know what happens behind closed doors, but I'm telling you, I see this, and every time it's brought up, every time a woman's in the corner, that allegation is made. 100% of the time.
the defendant has resided here for over at least 12 months in full over the 3 months.
Which is disgusting, because it does happen, and you water it down for the true victims.
Respectfully, the defendant sees this as there's more to say, but the defendant is having trouble with some anxiety.
Okay. Mr. Holmes, anything you'd like to say on the subject of the submitted letter?
No.
Okay.
Mr. Holmes, or excuse me, Your Honor, Mr. McGregor, the plaintiff, also throughout the course of this week has been telling the defendant that he wants to dismiss these cases, that he just wants the defendant to be reasonable, and that he will give her his vehicle in restitution for the vehicle damage and relocation, financial amount to relocate the defendant, and he's defined the specific terms, the length, and the amount, and he stated these facts and continued to state these facts up until Sunday at 8 p.m. And so the plaintiff requested that if an agreement was made in dismissing this case and this hearing not be held, that Ms. Hope, the plaintiff, would request that any agreements be written so she could have an attorney review the agreement and the soundness of it. And the plaintiff misled the defendant to think that this case would be conducted in a settlement agreement. And as such, the defendant has not had much time to be aware of what's really going on in this case, as much similar to most of these other cases, Your Honor. So I do beg and pray for the court to allow the defendant, Ms. Hope,
Judge, she just wants to work on her spreadsheets.
to seek legal counsel in how to move forward in the most reasonable way as described by the plaintiff, Mr. McGregor, in a setting where she is in time frame where she's able to purchase a new vehicle if need be, to relocate long distance and finish up her medical appointments, to receive and enter the mental health long-term treatment, as is planned by her therapist, her PCP, and her psychiatrist, and referrals to medical rehabilitation treatment for neurological injuries, Your Honor, sir.
All right, thank you. I'm going to go off the record just for a moment. I'll reconvene here hopefully in just a few minutes. Thank
Your
you.
Honor, before you go, I respectfully ask you to inform me as a person who's being forced to represent themselves via pro se under these conditions. What is this court hearing title, and what is the time length of this? Is this a trial? Is this a
Yeah, I got to go have a bump to get through the rest of this hearing.
pre-trial? What is going on?
This is with respect to your motion and my wanting to at least hear on the issue of the submitted letter. And I'm going to look at the file for a moment and I'll come back in probably 3 to 5 minutes. Okay.
Your Honor, yes, sir. And then what time frame is allotted for this? Is this a pre-trial or a trial, Your Honor, sir?
It's actually a hearing on your motion, the motion that you filed on the 18th of October.
For motion to stay the writ of restitution, Your Honor.
I had stayed the writ pending today's hearing date, and I want to consider first the question of this letter, and then from there we can go forward depending on the nature of the court's ruling.
Yes, Your Honor, I would like to relocate as soon as possible, please, Your Honor. So I pray that we can reset this soon, and that we can work together to come to an agreement where both parties have legal representation, as this process, all of this is causing undue mental distress. And I just want to move on with my life, sir. Please.
Thank you, ma'am. And I'll be back momentarily.
I want to come to an amicable resolution with this man who's committed SA against me repeatedly. Okay.
Thank you, Your Honor.
All right, we're back on the record rather in the McGregor versus Hope 24 LM 1193 case. I think that from my perspective, this may well be one of the more challenging cases I've heard. It's challenging to the extent that Ms. Hope has long had some good and reasonable explanations for the requests that she has made of the court. The court had sought to hear what she was saying and to hearken to her heart's cry where that seemed appropriate to the court. I think for his part, Mr. Holmes has done an excellent job for his client, and in point of fact, arrived at the destination that had been sought in terms of the orders the court had earlier made in the case. I do think that the letter from the 18th of this month, a week ago, is indeed, as Ms. Hope has explained, somewhat complex in that it has unequivocal language with respect to Mr. McGregor's willingness to not only with the case before the court at this time, but with respect to some other cases, take whatever action might be necessary to vouchsafe to Ms. Hope basically a change in what I'm understanding to be the current state of the record. I do think that that level of complexity does augur for honoring Ms. Hope's request for continuance. I am going to continue to stay the writ, the service of the writ. I'm going to set this over.
Just say it, Judge. You've had enough and you want to go home.
2 weeks to give Ms. Hope a chance to retain counsel, which she says she wishes to do. I think our next court date, or 2 weeks from now, I believe, is December 9. Ms. Baylin, how many cases are already set at 3:30 that day?
I have one set at 3:30.
Okay. Well, I'll set this one also at 3:30 and we'll take it up as soon as that earlier case is done. I do think it is important if there are additional documents that either side wants the court to consider that they be submitted by next Monday, the 30th of November, to the extent that those are available. I also understand that some documents might not be available by that date, but I would ask that they be submitted as soon as is possible thereafter. It looks like, sorry, I had said November 30th, I meant by December 2nd. And I do think it's important that we get to a finish line. Ms. Hope, you're requesting a continuance. I'm granting that continuance, but I would like to try to get this case finished up for your benefit, for Mr. McGregor's benefit. It has been now a fairly protracted matter, but I am going to give you a chance to do as you have requested here today, and I'm hoping that we can be at a finish line with respect to this case by the time we take evidence or have an agreement announced on December the 9th.
Your Honor,
Yes, ma'am.
I apologize, but may I speak before you close, sir?
Well, I'm happy to have you do that, but
Yes,
if
sir.
you're intending to hire counsel to assist you with this, it may be the case that you would benefit from having counsel's advice as you go forward with the case.
Your Honor, I just have two simple questions. Your Honor, I request the attorneys that I have conferred with, they have said that their availability, if you were to continue this case, would be no sooner than December 16th. And so in finishing up final agreements and hiring and choosing two, among two of the choices, I would request that in making a final decision that you set this case over to the 16th, also to allow each party to submit evidence that will involve also
Why are you unnecessarily wasting the judicial time of this court?
subpoenas for police officers of Andover Police Department who have been who've been present when statements of appeals were said to be in agreement by Mr. McGregor, and also in regards to allowing the defendant time to be able to get everything resolved with her vehicle so she can actually drive and participate in the requirements of doing all the filing of this paperwork, especially since the defendant is not being granted access to her USPS mail and has to travel 30 minutes to the Butler County District Court. And so this requires a working vehicle, and as such, the filings do.
This case needs Judge Chisholm in the worst way. He would not suffer this for 1 second.
State that there is record that Mr. McGregor, the plaintiff, has admitted to the defamation, the destruction and the vandalism and accessing and with of this vehicle, which by the way is only legally allowed to move with a mechanical device regulated by the federal government. And so Mr. McGregor has violated those federal laws as well. And also so to allow Miss Hope to be brave and be able to continue to receive therapy and psychological services to move and relocate and be able to
This started from, I have just two questions.
participate in the hearing for the 9th, Your Honor. I request that you grant the additional week, as this does involve 2 additional appeals of the matter, and there could be implications to what
You know the Hague is next.
happened in those other 2 cases, as this is a very complex case. And so I do ask you you reconsider the date, please. And I also ask for guidance on if the parties decide to expedite this prior for some crazy reason. So
Shut up and get out now. Instanter.
the defendant doesn't have to go through the undue distress of all of this. What does a defendant do when the plaintiff's attorney doesn't provide documentation of any settled agreements in the past that have been noted in these legal briefs regarding the case? And I also request that the judge order that the defendant, that the plaintiff's attorney submit the legal documentation in writing, so Miss Hope, the defendant, can have this legal documentation in speaking with legal representation in pursuing the next steps that you are adhering to your oath of legal conduct, which you have my deepest admiration and respect and appreciation for, Honorable Judge Pro Tem. Thank you so much. I ask that the defendant be able to understand what the plaintiff had wrote in that legal documentation and be able to provide it to legal counsel as well. Please, Your Honor.
Yeah.
Mr. Holmes, anything you'd like to say?
Yes, Your Honor. I don't know what we're doing. I've already got a judgment, and I don't have any intent of giving any more evidence or documents or anything. So I have no idea what she's talking about or what we're doing. And so as far as I'm concerned, unless the judgment's been set aside, we already have a judgment. You're staying this on the writ for us to come back and talk about having her removed from the home that we've been trying to get since August 13th. So
Your Honor,
I would certainly object to any further continuance.
Your Honor, I object to the plaintiff not providing communication of what he wrote in that document. The document's illegible. I don't understand it, Your Honor.
I think
I don't know what it says.
I believe the order is filed in the case, and I don't know for certain what other document you would be speaking of. I do, and I am going to hearken to your request to continue the case, but my thinking is 2 weeks, I would like to think, is enough time for you to get counsel hired, if that's indeed what you're going to do.
Or what? The stay of a writ? We're post-judgment. She's got to go. The best she gets at this point is a specific date. You can give her another couple of weeks to get out, to get her affairs in order, but she doesn't have an argument. She doesn't have an attorney, and she's already been evicted.
And I would like to think that that would also give you adequate time to prepare any further argument that you have in the case. I acknowledge that the letter does create some potential complexity, and I understand your desire to want to retain counsel. But beyond that, we can take up any further argument on your motion, but I think that Mr. Holmes is right in terms of desiring to get this to a finish line. And at this point, I'm doing exactly what you requested. I'm continuing the case
Yeah, Judge, if this woman was in your house, you'd find the finish line. Trust me.
to give you a chance to get counsel. We'll take up any further argument you may have on the motion at the next hearing on December 9th, and then hopefully we can come through to a conclusion at that time. And I'll just look forward to seeing each and all December 9 at 3:30.
Your Honor, if I may object, the defendant
This is
does
Kansas.
not know what the plaintiff's attorney submitted, the writing, based on the judgment, based on the order that was signed. So how is the defendant able to confer with counsel about this judgment if the judgment was submitted with transcribed writing by the plaintiff's attorney, Kurt Holmes of Wichita, Kansas, and he will not type it for the defendant
Well, the
to
order,
read.
the order and the writ were typed and submitted by Mr. Holmes.
I
And
I never received that, Your Honor, sir.
well, it's in the court file, and if you want to, if you're coming to El Dorado, as you indicated, you may be anyway, you're welcome to request a copy.
There will be no attorney. She cannot afford one unless there's some public aid deal. There will be no attorney. No attorney is going to put their pants on and walk to court over this.
From the clerk. For that matter, I don't know. I would have thought that perhaps that document had already been sent to you. Miss Baylin, do you know if the journal entry was sent to Miss Hope?
I don't remember off the top of my head, but I would assume so.
Okay. Well, if you would please just send her another copy as a courtesy.
Yes.
And Ms. Hope, you can take up any of the concerns you have with counsel whom you've indicated you've already spoken to, and they should be able to help you from there.
Yes, Your Honor. And if I may, I would also like to request to dismiss this eviction as well, seeing as Mr. McGregor has agreed to release any claims associated with this action as set in this agreement. And the defendant requests this because in the motion made today and in the brief and also submitted on the 18th, it did state multiple motions to modify, stay, or dismiss for lack of prosecutorial for possible.
I don't think it said for lack of.
She got down to prosicle. Well, nice try. Nice try.
Prosecution. I had reviewed that recently, but if you want to renew any motions along those lines when we reconvene, you're welcome to do that. I guess
we would love to revisit all of your arguments, plus any new ones you come up with between now and then.
My thinking is you had begun today's hearing saying that you hope to hire counsel to take up all of the matters that letter may be touching on. Is that what you want to do?
Your Honor, I respectfully am not well versed on the law. However, I believe this case is founded. It lacks jurisdictional jurisdiction because the case was. This is a.
Well,
okay. I'm sorry, Your Honor. I'm so sorry. I don't want to get into much detail. I'm just stating this request as it was a motion. So I'm making another appeal, Your Honor. I understand. I don't understand the complexity of it, but if you feel there's a legal basis cited in the case law and the court and the Kansas annotated case references in these case briefings with the evidence, I would request
In all seriousness, I've come to the conclusion she really needs a mental health evaluation. She really does. She probably needs to have a guardian appointed, and then this whole thing can be done. I can't imagine she's going to find other housing or be able to function in life. I just can't imagine she could.
That you also include that in your decision and whether to either dismiss this case and or if you don't see fit and if you see that it is has legal standing to dismiss, I ask that you do that. But I also request that if you don't find legal standing, then to continue it for the reasons listed in the briefs filed with the courts. And I also request that all these documents be filed in the court legal records that are available for public viewing as well, please.
All this because the guy was too nice, and what he said in his letter is, I don't want her to be stuck with an eviction. So as long as she's out, can we then like dismiss it after the fact so she doesn't have it on her record? He just wants her to go. It's very nice of him. And then she takes it as, oh, I don't know what. She just lives there for the rest of her life for free. I don't know.
Your Honor, to include specifically the written agreement, as none of that nor the journal entry have been filed on the Kansas judicial website, Your Honor. Do you believe there's judicial cause to dismiss this case, Your Honor, sir?
Well,
With
the
current
question,
evidence?
what you had asked me initially was to continue the case because of the complexity that was engendered by the November 18 letter. I had granted that request. Is that not what you're wanting me to do?
I'm asking you to do, if you can do both. I don't know if I'm legally able to do that, Your Honor, so I apologize. I'm pro se and I don't know. I don't know. So I'm asking you if there's legal basis to dismiss the case.
Well, in as much as you had initially sought to have an opportunity to hire counsel, I feel like I want to give you that opportunity. And if when we reconvene on the 9th, either through counsel or if you're still representing yourself, you have anything else you'd like to discuss on the motion or any other request you may wish to make of the court at that time, you're welcome to do that.
Your Honor, yes, sir. And my question is then in regards to this legal case, and again, thank you so much. I feel so grateful and honored for this opportunity, Your Honor, of Butler County, Kansas. And I'm so grateful the Air Force and the University of KU and Avila University and my medical providers and family and friends have given, and God have given me the strength to advocate.
Hey, shout out to the Air Force. I like the fact that they exist. I really do.
For women's rights, in a civil civil suit or any other possible criminal lawsuits that may proceed. I'm so thankful for the honor to be brave and the encourage of Representative Vic Miller to be brave in advocating for justice as a woman with the honor of having a degree.
There's the full dump of current culture nonsense right there. The whole kit and caboodle.
A bachelor's of social work who has an oath to advocate for legal rights. I'm so grateful. And I appreciate you allowing me to state that. I just wanted to apologize that I don't understand this process. So going forward, in order to receive documentation of what's going on exactly in these court cases, and this is my only way to access these court documents that I've been ordered to come to the Butler County courthouse because I'm not being permitted access to my USPS mailings, Your Honor. Is that the correct way? And what does the defendant do if the plaintiff attorney refuses to communicate with the defendant to receive this documentation or any? And
well, as we had
what do I
discussed,
do?
I don't know what, if any, additional documentation would be anything that Mr. Holmes would even have access to let alone be in a position to.
On what basis is she entitled to any documents? She's evicted. Discovery, to the extent it existed in this case, is over. I mean, I don't practice in Kansas, but I assure you, the discovery process ends pre-judgment. I don't know what the hell. I understand she doesn't know what she's doing. I don't understand the judge indulging it. I do not.
Have to make available to you. I don't know specifically what you may be speaking of, but I do know this much. I think that you filed a motion on the 18th seeking a stay and an opportunity to be heard today. I had hearkened to your heart's cry, initially at least, on the strength of the submitted letter and to try to ascertain what the meaning of that letter was from both yours and Mr.
Judge, if you say hearken one more time, I swear.
Holmes' client's point of view. You had sought an opportunity to hire counsel to assist you, given what you've explained is the complexity, and I understand where you're coming from there. And I have granted your continuance request to December 9th, and we will go from there. And certainly, if you do indeed hire counsel, I would suggest that that person will probably be able to assist you as well.
Your Honor, but to get the written orders that come as a result from today's court hearing and November 8th court hearing, and it's the only way for the defendant to come to the court is to the Butler courthouse.
The only document that will be coming out of today's court hearing is just a notice of the new court date that I've just given you, December 9th. I don't suspect there'll be any other written document coming out of today's court hearing.
Will these documents be submitted to the court case on the judicial court case record for public viewing?
Yes, they'll be in the judicial record. Filed in the clerk of the court of Absentia.
As all the other documents have been submitted, Your Honor, will I be allowed the same legal right to have those be timely submitted on this court filing?
You'll be sent a copy of the document that will have the new court date on it, and any other document that's filed in the normal course of business should be accessible electronically.
But the filings I filed with the court have been submitted for the motions to postpone the court to continue the case. Is there going to be additional documentation posted on the court?
If you submit additional documentation, I suppose so. Mr. Holmes already indicated he doesn't believe there's any other submission necessary by his client, Mr. McGregor. But Ms. Hope,
I'm so sorry, Your Honor.
No apology necessary, but I've sought to answer your questions, and I do understand that you had begun by asking for continuance. I've granted that request, and I'll just look forward to seeing you and Mr. Holmes and Mr. McGregor on December 9th.
Your Honor, do you believe that this case should be heard before a different judge as this case is?
You had raised that specter before, and I had ruled on that specter before. I never ascertained from you that there was any reason other than you didn't feel comfortable. But
you will never find another judge as indulgent as this one is to you. No matter where you look. I'm all in favor of it. Recuse yourself, Judge. Hand it over to Chisholm. We'll have this thing knocked out in about 35 seconds.
I never knew what it was specifically, and as the record would otherwise reflect, in prior hearings, you have at once told me that I was doing a good job, and then told me that you might prefer to have another judge
But I'd also like to see O'Donnell take this one on.
assigned to the case.
In lieu of new evidence,
I think
filings to the case stating there's 3 lawsuits.
If
Your
you,
Honor, I respect
let me stop you for 1 second.
My
If
apologies.
if you have anything else that you want to add by way of further motioning the court, you're welcome to do that. But I would encourage you, please, to get that in before the second, so that Mr. Holmes could have a chance to look at that as well. But those will be the orders of the court.
Okay. Yes, Your Honor.
Forward to seeing you guys.
Yes, Your Honor.
Thank you.
Thank you. God bless you guys. Thank you.
And
Thank
you.
you all. Thank you so much. Miss Belen Wells, Miss Wells, thank you so much for your help. I hope I'm doing this process correctly. I sent you an email. Can I call you later tomorrow, ma'am, if I have questions?
Julie, if you have questions, you're welcome to phone me, yes.
Thank you for your professional integrity and communication. Thank you all. Bye-bye.
All right. We are on the.
All right. There you have it. You can say anything you want as long as you say God bless you at the end, and it's all okay. This case is over. I don't know why he's doing that. I mean, he knows more facts than me, but I don't know why he's doing it. She needs to go. The plaintiff sent a letter saying, hey, I'll help you out so that the eviction's not on your record after you get out, effectively. And the judge, and then she tries to conflate that into he doesn't really want to evict me. Which is laughable, except the judge is buying it. Oh, there you go. Direct all comments directly to Alyssa. There you go. There you go. Thank y'all for coming out. That was fun. It was maddening, but it was fun. I'll see y'all soon.